And welcome back. Will Worsham joins us now for this week's Speaking Legal discussion. Good to see you again.
Hey, good to be here again.
Yeah.
What's new look? Look at this.
Yeah, something's different.
I'm going to try to get some contacts going on and see if that will work out for me.
Well, we know people if you need contacts.
Do you? Okay, that's good to know.
All right, you ready for the question?
Sure, you bet.
Okay, here we go. Is it better to move out of the house before filing for divorce or not? Also, what about custody? Do I need to have my kids when I file?
That's a lot of questions.
There's a lot of questions.
Where
there.
do we start? Move out of the house?
Yeah,
or no?
let's talk about that first. So there's people that are kind of two minds about that. You know, ultimately we're talking about an equitable distribution of the assets of the marriage. Some people feel like if you move out of the house, it's kind of signaling that you don't want it and you don't want to be in the house.
I've read that before. It's like you're deserting the situation.
Yeah,
abandonment or something.
Well, not of the property of the children. That could be an issue, but you don't. You know, it's supposed to be an equitable distribution, so it really shouldn't matter. And you may need to get out of the situation anyway. So you kind of have to do what's right at the circumstances, considering everything that's going on. I don't necessarily have a problem if somebody moves out of the house. I think you can still make a claim that you want it. But if you really, really, really want that house, it's probably better to stay in it and be living in it at the time. But I mean, there's so many other factors that come into play there. It's really hard to make a specific recommendation.
Would an attorney possibly have the best judgment on what might be right, what might not be in a case like that?
Yeah, that's really the best thing to do is when you sit down with your lawyer to tell them everything that's going on, what your goals are, what you want to have happen, and then let them give you specific advice in your specific situation. But in a general sense, it's really hard to give an answer to that because there's just too many different things that could be going on.
A lot of variables, moving parts in that kind of a situation. Okay, speaking of custody, now what about the kids?
So
how do we even start with this?
They're ultimately, at the end of the case, we're going to do what's in the best interest of the children.
Right.
But there is a presumption that whoever has custody of the kids at the time the divorce is filed can at least maintain that custody while the case is pending in the absence of an emergency motion to the contrary. So a lot of times we'll see, you know, maybe one parent moves out and takes the kids and files. So there's a presumption that is going to be the custodial parent, although we don't really use those terms anymore, while the case is going on until there's a final decision. If you disagree with that, if you think the kids are in danger or they're going to be neglected or there's an additional problem with that parent being the custodian of the parent, then you can file emergency motions and say, Judge, this is not a good situation. I need those kids returned to me.
It sounds like what you said there was if they move out and they take the kids.
Right.
Yeah,
I know.
That sounds like you took. That's
took.
like I mean, it may be the wrong word, but it's like that's akin to kidnap.
Yeah, it's really not in that scenario. Where it's going to come down to is the court prefers children to have a relationship with both parents unless there's a reason not to. And so if you, take the kids and then don't let them see their other parent, that's a problem. Unless you have a good reason to deny that type of visitation. But as long as we're being fair, and you can flip that scenario. Let's say one parent moves out and the kids don't go with them, leaves them at home. Then the parent that's at home has custody of the children at the time the divorce is filed. So it doesn't have to be a leave and take, it can be a leave and left type scenario.
Okay.
All right, and all this will go into the parenting plan,
ultimately,
which is all written out so everybody agrees and everybody. But you can change that plan if necessary.
Parenting plan can be changed
by going to court down the road. How long, by the way, is one responsible until what age for child support? I always thought it was 18, but now I'm hearing something different.
It's 18 or up to age, I believe, 25 if they're enrolled full-time in college.
Okay, interesting. So if one parent has the children and later one moves with the other one, do we need to go back and rethink our child support?
Yeah,
absolutely.
Okay, so there's no reason not to do something like that.
Certainly.
I always thought 18 was it. I did not realize.
Well, I did, but I knew it had changed, and if one does change the parent you're staying with, you need to get that all reworked then.
Interesting.
So nothing is etched in stone forever.
Not with the kids, because we always want to be able to do what's right by the kids, so we're never going to make that unmodifiable.
Okay, very good. If you have a legal question, email him at wworsham@colorton.com and he will answer your question on the show. Thank you so much. Good to see you. All right, tax day officially over. Hallelujah. Bruce Porter wants to help you start planning for next year. It never hurts to plan ahead. He's up next, so stick around.